Okay, so good afternoon, everyone, and welcome to our Law Talks virtual workshop series. My name is Stephanie Bowe, and I'm with the Louisiana State Bar Association. Today's Law Talks is on common labor and employment issues, and we have clinic professor Luz Molina from the Loyola College of Law, New Orleans, Workplace Justice Project presenting on this very important topic. Before getting started, I do have a few things, a few important reminders to go over. So first, this presentation is being live streamed on Facebook. Second, all questions are going to be taken and answered at the end of the presentation. If you're watching at a library, you may ask or submit your questions through library staff. If you're watching via Zoom, please submit them in the Q&A section. And if you're watching live on Facebook, please submit them in the comments section, and we'll get these to the presenter at the end of the presentation. Please do note that all comments are public and accessible by anyone during and after this presentation is over. We do have some disclaimers. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on the information provided in this presentation without first seeking legal advice from counsel in your relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Civil Legal Navigator, and the website is located on this slide. And we'll talk a little bit about it later. Also, the LSBA's inclusion of a program is not deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentation or materials were free of errors or will continue to be accurate. Statements in this presentation and the materials should be verified before relying on them. Opinions and views expressed are those of the speakers and contributors only and do not reflect the opinions of the LSBA, its sections, or committees. Okay. I'm happy to, like I mentioned, Professor Luz Molina is joining us today to present on this topic. Professor Molina is a graduate of Tulane University School of Law. She has been a part of the clinical faculty at Loyola College of Law in New Orleans for 36 years now. She supervises student practitioners in labor and employment practice as a part of her Workplace Justice Project, which was created after Hurricane Katrina to redress some of the large-scale abuse of workers earning very low wages. She's involved in various efforts to bring systemic change to the law and to the legal profession. She is an active member of the Louisiana State Bar Association, where she works with other members to improve our most vulnerable citizens' access to the courts, notably those marginalized by lack of legal resources, the inability to pay, and or because they have limited English proficiency. So we are very excited and thankful to have you here with us today, Luz. I'm going to go ahead and turn it over to you.
Thank you, Stephanie. So good afternoon to everyone. And just note my appreciation that you've taken the time to listen to this presentation. I think it's important that we understand some of the rights that we have. It's not always easy to access this information if you're not a lawyer or have not had that experience previously. So we've chosen three particular topics that might be of interest to you. One is an overview of employment discrimination. The other one's the Wage Payment Act, and the other one's our right to engage in protected concerted activities. We're going to start with employment discrimination. So there are two sets of laws. There's the federal and then there's the state. Most lawyers will file in federal court, but can also access the state law. So it is unlawful under federal law for a company to discriminate, treat you unfairly, or harass you because of your race, color, national origin, religion, sex, and sex often includes pregnancy, gender, sexual orientation. It's unlawful to discriminate because of your age, disability, or because of your genetic information. The state law also has a very parallel system of laws that protect you, and they often become complementary one with the other. It's under Title 23. If you have access to that, of course, that is public knowledge. You can get on the website and take a look at those laws directly, and they're under Title 23. So how are these laws applicable? So discrimination based on those factors, race, color, religion, sex, or national origin, are enforced for companies that employ more than 15 employees, or 15 or more. It prohibits retaliation against employees who file complaints or participate in investigations. And we'll talk a little bit about how important it is to participate in the investigations if you feel you've been discriminated against. Discrimination of individuals with disabilities, the ADA, American with Disabilities Act. It requires that the employer give you a reasonable accommodation to a disability unless it poses an undue hardship. So what is a disability under the ADA? A disability is something that affects major life functions. For example, for a long time, diabetes was not one of those issues, even though it did affect major life issues, life functioning, but now it is. So if you suffer from a certain level of diabetes that can affect your work, then you're protected. It covers employers who have 15 or more employees. Discrimination of employees because of age starts at 40 years. If you are 40 or over and you're discriminated because of your age, you're also protected. In this case, the employers have to have 20 or more employees. I would note that for this kind of age discrimination, if the difference between the discriminator or the way that you were discriminated is too close to your age, oftentimes those cases will fail. And just so that we understand, of course, discrimination when it's based on sex, it rightfully includes pregnancy. Of course, here we have gender, sexual orientation, but in the pregnancies, childbirth and related medical conditions. In the state of Louisiana, they have additional protections. There's a new act, but that act does not necessarily exist at the federal level. But in a lawsuit, those two laws can be complementary. And for pregnancy, it can dovetail a little bit into the ADA for purposes of protection, because all of these protections have timelines. How long are you allowed to be given, are allowed to take off and things like that. Now, how do you go about it? All of these protections must start with the EEOC, the Equal Employment Opportunity Commission. And this commission is the federal agency that enforces the laws against discrimination and harassment. And if I didn't say it, if you are harassed because of any of those factors, race, religion, etc., that is also covered. The EEOC requires you to file a charge of discrimination before you can file a lawsuit in court. That is, if you do not file a charge with the EEOC, it's called administrative review, then you will not be able for most of these discrimination charges to file an action in federal court. The only exception is the Equal Pay Act, which is difference in pay between a male and a female, or a male and a female and a male in terms of their salaries. Next. So as I said, I can't emphasize enough that you must file the charge before you can pursue some kind of lawsuit for discrimination. And of course, there are times when your charge is very successful and you can resolve it at the Equal Employment Opportunity Commission level. There are strict time limits for filing a job discrimination complaint with the EEOC. In the state of Louisiana is 300 days. That's longer than it's allowed under the law. And the reason that it's longer is because the state of Louisiana and the federal government have a memorandum of understanding where they collaborate. The state laws on discrimination are enforced by the Human Rights Commission, but most attorneys will file in federal court under the federal law, and it will be handled by the EOC. Now, sometimes the EOC, when it's overwhelmed, will refer some cases to the Human Rights Commission, but hopefully they'll stay with the EOC. It's a more streamlined process. Now, a little note regarding those 300 days. Note that it's, let's say the Discrimination Act is termination, then you have 300 days from the termination. But let's say the Discriminatory Act is, let's say 30 days before termination. Your time starts ticking at the time of those, at that month before. So you're shorter than 30 days from the 300 days. So you got to make sure that you know that you use your calendar to count those days, because once you miss that deadline, you are no longer able to pursue whatever discriminatory relief, what relief you might want from discrimination. So what does the EOC do? It investigates, it'll ask for documentation, it will ask for names of people who you feel participated in the discrimination, and in certain instances, well, it will have one of several reactions. Number one, it can say, okay, we think that there's a lot of validity to this claim, we're going to attempt mediation. If the employer agrees, then the EOC will serve as a mediator, they'll assign a mediator, and you may be able to settle your claim. In some rare instances, it may take the action itself. The EOC becomes the plaintiff on your behalf if they feel the action has a lot of value generally, and they'll bring the action against the employer directly. They want to send a message that that behavior is not acceptable. And in most cases, they will issue a right to sue. So what does that right to sue letter say? Well, it could say, we find that there's been discrimination. That's really the optimal result. It can say, and means they may not have gone to mediation, but they went ahead and kept on investigating and found that there is a valid complaint. Or in a lot of cases, they'll say, well, we've investigated, it's not clear what it is, but go ahead and sue if you want. Now, you have 90 days from the date of that right to sue letter to bring an action in court. And I would encourage you, absolutely encourage you, to start looking for a lawyer right away if you're interested in pursuing the matter. Most lawyers are very shy about accepting a case on the eve of those 90 days, because you need, as a lawyer, to look at all the facts, see how the law was not followed, what your evidence is like. And so we'll talk a little bit about documentation. All along, if you feel that you're being discriminated on one of those bases, start documenting. What does that mean? Make sure you could keep a journal with the dates and the people who took a certain action against you. Things like that. If there are papers that are given to you, save them. Make a file folder and start putting everything. Recording conversations, but I mean, you can write what happened in the conversation, who participated, who was a witness, because in the end, this may be very helpful. Next. Now, again, I'm going to say, if you do not file within those 90 days, then you will lose your right to file. Your case ends at that point. Now, how do employers generally defend these matters? Well, one of the typical ones is that They say there's a legitimate non-discriminatory reason for their employment actions, your poor performance. Sometimes they dig into your record. They go through a lot of materials to see if perhaps you were really a poor employee. Oftentimes, plaintiffs will have an exemplary work performance, and all of a sudden they become terrible. So document all the compliments, all the things. If you think you are vulnerable to some of these discriminatory actions, make sure that you're following, that you're observing what's going on in your employment. Some employers may have an issue. There are certain exceptions in terms that giving the employer a defense, and it's called a bona fide occupational qualification. What does that mean? That the job requires certain things that the employee cannot do. And so it's a valid action to have terminated you. It generally comes in those terms. For purposes of disability accommodations, a valid defense by the employer is the undue hardship, meaning that if you have a life condition, a medical condition that affects your life and your ability to do the work, and it causes undue hardship to the employer, he's not obligated to give you that accommodation. So make sure you understand what your job requires. Make sure that the employer knows that you need the accommodation, and be clear. If you have medical information, give the medical information. The employer is supposed to sit down with you. Once you notify the employer that you are requesting an accommodation because of your disability, the employer is obligated to sit down with you and work out a way in which the accommodation should work. Now, remember, you have to be reasonable about what is possible within your employment. Doesn't mean you have to give up, but you have to, if your demands are unreasonable in terms of the needs of the employer, you're not going to be successful. I would, when you go through that process, if you don't go through that process, make that notation, because that's significant. The employer should know that he must go through, or she must go through, a process of assessing what your obligations are as the employee with the accommodation and what the obligations of the employer are in that accommodation. So make sure you understand and ask questions when you sit down with HR or whoever's doing that kind of process with you. And ask, I need to sit down and figure out what's going on. Now, in any event, whatever the discriminatory action is, you should report it to the employer. I know some employees are shy and they think that nothing is going to get done. But if the employer is offering, even if the employer is not offering anything in their manual about how to file a complaint, go ahead and approach HR. Just don't give it all. Just say, this is happening, I'm being discriminated this way and that way. Document the day you went there, follow up, because if the employer knows and does not do anything, that works against the employer. But if you go through that whole process and you don't document, and the employer decides to say, well, she never came to me, he never came to me, then you've got issues of proof. He said, she said, and you do not want to get into that situation. So I highly recommend that you be aware as an employee of what's going on in those instances where you feel you are vulnerable to discrimination. Now, in the end, it's your burden as an employee, as a plaintiff, to show that the actions are discriminatory. So let's say the employer gives a legitimate non-discriminatory reason for terminating you or for doing X, Y, Z. You don't have to be terminated in order to file a complaint with the EEOC, by the way. Of course, makes you more vulnerable, let's face it. People are human. So if you file a claim while you're still employed, they may still terminate you. They find other reasons. So once the employer gives a reason that appears to be legitimate, you as the employee, your lawyer, with your facts, must show that that reason was a pretext. So for example, you're a terrific employee, every single evaluation is just 100% good. And all of a sudden, when something appears to be discriminatory starts happening, your evaluations go down the tubes and you get terminated. Well, there's a great possibility that their answers are a pretext. And so understanding how you might articulate that is really important to your case. Next. So what are the potential remedies for discrimination? Back pay, obviously. It's what happens from the discrimination to the time that you either settle it or get a judgment in court. Or front pay. Now, front pay is not very common, is if you were in a position where you cannot find another job, and so you make less, or you're somehow preventing from earning future monies because of that discrimination, that is front pay. It's very rare to have front pay, but in certain situations, it may be the thing that falls into place for you. Reinstatement or the promotion that you were denied, if that's part of your claim. In my experience, employers don't want you back once you've sued them, so you tend to just take the money and go away. In some cases, they might reinstate you, but I find that mutually, the employer and the employee never want to get back together. It's a total divorce at that point. Compensatory damages. Punitive compensatory damages are out-of-pocket things that you suffered as a consequence of that action. Punitive damages for discrimination, except for ADA claims, the Americans with Disabilities Act, there are no punitive damages for a violation of that. And attorney fees, I think it might, for ADA claims, liquidated damages, which work differently. Attorney fees and court costs. So that's a separate thing. And a lot of attorneys, if it's a really good case, will take the case knowing that if they win, they will be able to collect attorney fees and court costs at the end. But, each attorney makes his own determination or her own determination of whether the case has merit and likelihood of success. Next. Let's talk a little bit about wage payment in Louisiana. Louisiana does not have, at the outset, I'll say that Louisiana does not have a state government-sponsored administration of non-payment of wages. The Workforce Commission manages unemployment compensation, workers' compensation, but it does not manage non-payment of wages, even though it's in the same Title 23. So the sad part on this is that it is the onus on collecting unpaid wages is on the employee himself or herself. So if you were not paid, then you try to settle it with them and you end up having to sue, then you will have to find a lawyer and sue unless you do it yourself. There are just also, secondly, the Fair Labor Standards Act, FLISA, or FLSA, is the wage payment act for federal law, but they act very, very differently. The FLISA regulates an hourly rate of payment at the national level and the payment of overtime, among other things. I mean, it's a complicated law, but what you might want to know here is what it controls. The LWPA, the Louisiana Wage Payment Act, tells employers that they must pay their employees for their work in a timely way. And the statute number is here. And it's at RS 23. 23 is the title, 631 is the section, 632. There are a few sections that talk about what the obligations are. So let's talk about the Louisiana Wage Payment Act first. I think that's really important. These are the key issues if you're not been paid. It applies only to employees, not independent contractors. And here I'm going to take an aside because this is a very contentious point legally, because the idea of an independent contractor is not, it's a legal issue. It's not up to the employer to decide it in some ways to avoid having any obligations as an employer as opposed to a contractor, right? So what does an independent contractor mean? It's somebody who does not fit the model of an employee. And so what is the model of an employee? Well, an employee can be paid by the hour. And by the way, the Louisiana Wage Payment Act applies whether you're paid by the hour, by the day, by the month, by the piece of, making 3 shirts an hour, whatever they're going to pay you. The workers paid that rate because, and it's set by the employer, for example. That would point to an employee relationship. What else? Well, what if the person is told to show up, when to take the lunch break, all of those things, when to quit? That is the mark of an employee, because independent contractors tend to have more freedom to set their schedule. And also they have freedom to set the prices, right? Here we're talking about you're told you're going to be paid X. And what if the employer interferes all the time? You didn't do this job right, redo this wall, redo this floor, redo X, Y, Z. That also points to the relationship being one of employer-employee and not an independent contractor. So just note that if in some ways the employer is trying to avoid invoking the Louisiana Wage Payment Act, they may answer a lawsuit by saying that the person is not an employee, but they are an independent contractor, and therefore the law does not apply. If that happens, your lawyer would have to litigate not only what's owed, but the fact that you're not an independent contractor, but an employee, and therefore can avail yourself of that law. What else is significant about this law is that it's enforceable only upon resignation or discharge. And that is unfortunate sometimes because if you have not been paid for several weeks and you continue working, you can't just sue for those several weeks. You would have to be terminated or resign in order to have that law enforced. You have 3 years. We call it prescription in Louisiana. In other states, it's called statute of limitations. You have 3 years from the time of non-payment to bring the action. Next. So what does that mean, 3 years? One little example is that, let's say that you were not paid in the 6 months of the year for 3 weeks, but you continue working. And then down the line, you get terminated. Your 3 years start from when you first did not get paid. So it's not 3 years from the time of your termination. So be mindful of that. Most times what happens is one coincides with the other. You don't get paid, you quit, and then you can make that claim right away. So it'll be your decision, but just know that your counter starts earlier than termination if you were not paid several months before and you continued working for the employer. So this statute requires the employer to pay you on or before the next regular payday, but no later than 15 days after discharge. So you'll have to do the math, which one. It's important to note that. Vacation pay, if it is earned, it's considered a wage under Louisiana law. And this year, the last year, and it just took effect, the legislature decided that the issue of commissions and bonuses, which were under law, the jurisprudence as we call it, what the judges said, had to were wages now and have to be in writing so that there's no dispute as to when those bonuses and commissions are due. There was a lot of dispute if the person quit earlier or was fired earlier, or the payments under that commission were not paid until the person left. So there were a lot of uncertainties, excuse me. And so now generally there'll have to be a written policy that clarifies that issue. The other thing I would say here that's important is the employer cannot impose any fines on you. That's prohibited by this section of the law. And in addition, if it tries to claw back, let's say that you accidentally broke some plates if you're a waiter or waitress, and then they try to charge you more, they can only recover what if it's negligent, and only to the extent that the damage, the value of the damage. So make sure that you understand that if you ever experience that kind of situation. The payment must be made at the same location and the same method. Generally, you go up to the employer and they'll give it to you. But if the employee is gone, make sure that your employer has your address to send the check to you. Next. Now, here there's a lot of controversy, not in the law. The law straight out says if there is a dispute on the amount owed, the employer must pay the undisputed portion when there is an undisputed portion. If the employer fails or refuses to pay, we say they owe penalty wages, but it's really the judge imposes. It's the job of the judge to impose the penalty wages. So, excuse me, wages from the time of demand until payment, or 90 days of wages at the worker's daily rate, whichever is lesser. So it, again, it's an issue of math. So how do you go about asking for your salary for whatever was not paid? In order to be able to ask for penalty wages, and we'll talk a little bit about the law surrounding that, worker must make the demand on the employer. There's no prescribed way. You can do it in writing, or you can tell them, please give me my money to be paid. But I cannot say this strongly enough, the demand should be in writing. You can tell it immediately, say, I need to be paid. And when you write your letter, just simply say, I told you on this day I need to be paid. I need to be paid. Make it in writing, keep a copy, make sure you ascertain that it's been delivered. You gave it to him, make a note. It was sent by mail. You can send it, make a copy of the envelope or something that gives you some credibility that you may demand. Next. Now, penalty wages have to do with the good faith or lack of good faith of the employer. So the good faith defense, if the court finds that the employer's failure is in good faith, only the wages owed plus judicial interest from the date of filing will be awarded. So when are employers in good faith? A simple mistake of math, or the computer got a glitch, or something that doesn't evince any intent to not pay. The harder issue is the lack of good faith and the proof that is demanded. How do you prove a negative? But if he's not in good faith, then the court should award penalty wages, as we spoke about in a few minutes ago. So what does the court say is lacking in good faith? And that's hard to say, but one of the ones that we've seen very consistently is when the employer acts arbitrarily in not paying you. One of the more troubling issues we have seen, however, is where the employer does not pay what is undisputed, disputes the other part. The court says, oh, well, he was in good faith. But clearly, if he refused to pay the undisputed portion, which is mandated by law, one might think he lacks good faith, right? But the judges are very inconsistent throughout Louisiana in figuring out, it's a case-by-case basis. And so make sure you understand the motivation of your employer if you are going to ask for penalty wages. Most actions will ask for penalty wages, but then it becomes an issue of evidence. It is unclear who has the burden, but the judges don't seem to say who has the burden of proving the lack of good faith or having good faith, but often seems to be falling on the plaintiff to point the finger at certain actions by the employer. So what you can take away from this is that it's not guaranteed. It's something you ask, and it's awarded by the court based on the facts of the case and the lack of good faith. So when can you file it? The statute says you can file a court proceeding at least after 3 days, 3 days or after making the first demand for unpaid wages. And again, it's a question of math. We talked about it has to be paid by the next pay period or no later than 15 days from termination. If the claim is well-founded, even if you're owed $1, attorney fees, reasonable attorney fees will be awarded to the plaintiff's attorney. Now, let's talk a little bit about FLISA, the Fair Labor Standards Act. There are a couple of things you need to know. The Fair Labor Standards Act requires that most employees be paid at least the minimum federal wage, which is currently set at $7.25. FLISA exempts employees that are executive, administrative, or professional from coverage. But in order to be exempted, meaning they don't get paid over, it doesn't apply generally in the overtime issue, which we discuss in a second. And for that to happen, the individual must earn at least $58,656. This is the new number as of January of 2025. And this arose out of some large discussion about some of the managers from Dollar General, these dollar stores were making very little and working too much, and were not eligible for overtime pay. So the control of the overtime pay, and may I say, for those of you who don't know this, Louisiana does not have a minimum wage statute. So in Louisiana, certain employers, well, most employers will look to the Fair Labor Standards Act to set the minimum wage. But in some instances, the Fair Labor Standards Act will not apply. A lot of the cases in construction work for construction workers, it won't apply for small businesses. Overtime pay, and what makes the difference here is that Fair Labor Standards Act acts on the authority that you're affecting interstate commerce. So for example, this is the classic example. If you're a waiter or a waitress and you run the credit card of your customer, you are covered because you are affecting interstate commerce, since credit cards run interstate. They're out of Maryland, New York, all those through the wire. If you're a secretary opening correspondence from other states and managing deliveries from out of state, you're covered. But if you are the bus boy you are not covered because you're simply cleaning up a table and you're not affecting interstate commerce. So that's the simplest way to make that point. Overtime pay, obviously under FLISA, you are required to be paid for 40 hours per week, and the week can be defined as any set of 7-day period. Doesn't have to be Monday through Saturday or Sunday. So for example, but anything above that, you must be paid time and a half. So for example, if you earn $8 an hour and you work 45 hours in a week, the employer will owe you 40 regular hours at $8 plus 5 hours of overtime at $8 plus 1/2, that's $4, $12 per hour. That's an additional $60. And I want to make a point here that's very important for those of you who might be affected. This is a law that's applied weekly. So let's say that you get paid every 2 weeks, and every 2 weeks you have 80 hours, and the employer pays you regular time, except that some weeks you work 35 hours, in another week you work 45 hours. The employer must pay you overtime on the week that you worked 45 hours. He cannot just all add it up and get it to 80 and pay you regular time. So he will owe you overtime. So make sure you understand that if you're in that kind of situation. So the 35 hours will be paid at regular time. The 45 will have 5 hours of overtime. Next. One last little reminder, in this day and age, the National Labor Relations Act, I will say that it was enacted in 1935 in the middle of, or right after the Depression. It covers two things: unions, of course, and obviously that is a problem nationally. It's very low unionization in Louisiana. The last statistic in 2023, only 4.3, 4.8 of workers belong to unions. And when you have a union, you will have a union representative, and those contracts will be negotiated by the union on your behalf with the employer. So we're not going to get into the thick of that because it can be complicated. But I will say something about union work. Louisiana has a law called right to work law, for those who you might not have heard of this. What does that mean, right to work? It doesn't mean you have a right to work generally. It means that if you're in a unionized shop, as they called, then, and you don't want to pay the dues of the union, you don't have to. And I think that has contributed to a lot of the unions having more members, just generally speaking. And Louisiana is one of the lowest unionized states. Next. So the NLRA has a second provision, which you might want to know in case this happens to you. And I thought it would be interesting because it's not talked about too much. It's very important. It ensures that employees have the right to engage in collective action to better, sorry, a little misspelling, better the employment conditions. And you don't need a union. So an example of this is that if you decide to meet with several employees at your house because the benefits of the organization are not good enough, or the income or whatever, then the boss finds out about this and then fires you. That's a violation of Section 7. Next, and then you can make a complaint to the NLRB, the National Labor Relations Board. next slide, because I think we have some information there. So here's how you can file a claim. It tells you within what time. In that case, the board will represent you, meaning that you don't have to have a lawyer to go along with you. You just have to explain. I had a case similar to that where they met, they were getting paid almost nothing. They decided how to approach the employer. The employer found out and within 2 weeks had fired all the employees who had gotten together. So that is what a Section 7 violation is. You don't need to be a member of a union. You just need to come together as a group to better your conditions of employment or your terms of employment, and as whatever the deal is for you. So just keep that in mind if that should happen. And there is a process. When they receive it, they investigate it, they take evidence, they'll be right there. If they determine there's a violation, they'll try to get a settlement. And if no settlement is possible, it'll go to the National Labor Relations Board for a decision. Now, the remedies are reinstatement of the workers, back pay, cease and desist in some instances, but mostly back pay and reinstatement, although, as I said before, often employer doesn't want the employee and the employee doesn't want the employer. And there is an appeal and review if you feel strongly enough and you want to pursue it if the NLRB dismisses your claim. Thank you so much for listening. I hope some of this information was useful, and I look forward to hearing your questions. See if I can have an answer.
Thank you, Luz. We've actually had quite a few folks that have joined us on Facebook, and we have had some questions submitted already. But if you do have a question for Luz, please submit it now, either through the Q&A section on Zoom or by using the chat, the comment section on Facebook. So Luz, the first question we received was, are there any protections for employees of 501c6 nonprofits with only 2 employees? I've been threatened with being fired several times because of my disability.
Well, this is a very personal question. Obviously, we're not giving advice. The information that we've given here today is that the ADA applies only to employees of, what is it, 15 employees? Let me see. Because some are 15 and some are 20, but the ADA, I believe, is the 15.
Yes.
Yeah, 15 or more employees. So just reading that particular information, that would give you the answer to that. And I'm sorry, we just cannot give advice. But feel free to, I will say there is an organization called PELA, Plaintiffs Employment Lawyers Association. That's the website, and you can always get maybe a lawyer to give you correct advice. But I have not seen any exceptions to that law on the basis of nonprofit status.
The same person asked a follow-up question. Can a business with less than 15 employees opt in legally to follow EEOC guidelines?
I've never seen that. In my 46 years of practice, I have never seen an employer subject himself to these kinds of protections. Now, the employer himself, by contract, can provide protections to you, but remember that we are an at-will state. Employers can hire and fire you for whatever reason, unless they're discriminating against you. And of course, you have jurisdictional issues of how many employees and that kind of thing. So,
right. Same person is asking another question. This seems very specific to their situation, but I'm gonna read it in case there's any information you can direct them to, Luz.
that's mhm.
as a salaried employee of a business with less than 15 employees, my work has stated that comp time will be issued at the sole discretion of the executive director in 4 or 8-hour increments. I was told verbally I would be compensated with comp time for extra time spent working on a project outside my normal work hours. However, when I submitted for comp time, which was 3 days, I was denied and told that I get plenty of comp time already. She asks, or they ask if this is legal or would this fall under unpaid wages? Or is
Again,
it,
this
yeah,
is very specific,
yeah.
but I would say that any work that you provide and it's not paid for is unpaid wages. The question is whether a judge would argue, you would have to quit or be fired and then sue for that comp time and explain that it wasn't paid. Now, again, I am emphasizing this. You got to have documentation for all of this. And it seems like you might have some documentation because you submitted it, it was denied. But that's a problem, trusting the employer right there. But again, I suggest you consult a lawyer. But it may not be worth it. And, I mean, a lawsuit in Louisiana in state court is $500 to just sue. In the lower courts, it may be $375. So it's expensive.
All right, and we have another question. I'm an administrator for an employer with less than 15 employees, but I'm paid less than 58,000. Does that mean FSLA would apply to me?
It looks like it. I mean, starting in January, if you're an administrator, but if you are working, you may be eligible for overtime. It may be something that you need to explore with a lawyer if that is of interest to you. That's the new number. It used to be much lower. So at that time, you would not have been subject to overtime under FLISA. But as of January, it's 58,000, I think 536, something I said, something like that. So it looks like you might be covered by that. If your situation is where you're working more than 40 hours a week.
That was all the questions we received so far. We can give it another minute or two for folks to enter any questions they might have. In the meantime, let me share some other resources. Right. So if you need any additional legal assistance or information about this topic or other civil legal issues, please check out the Louisiana Civil Legal Navigator, which you can find on our LSBA Find Legal Help page at www.lsba.org/go-to/find legal help. You can see that by the first arrow, the Civil Legal Navigator, if you click there, you can access it. And then the other resource that I want to point out that might be helpful is if you're watching this recording at a later date and you may have a question, you might be able to get that question answered by using Free Legal Answers. This is an online platform that allows you to log in and submit your question through their online portal, and then it might be answered by an attorney. So again, if you're watching this at a later date and we're not live where you can ask your question, you might be able to have your question answered there. And then another resource we have is our legal help access points. You can use these to get assistance with your civil legal issues. These access points are physical computers or booths that allow users to access a spectrum of services, as you can see listed here. There's legal information. You can get customized legal information and referrals, see if you qualify for legal aid. You can schedule meetings with legal aid attorneys, and you can attend virtual court hearings in participating jurisdictions. These access points are currently located in libraries in Lake Providence, in Faraday, and in DeRidder. There's also one in the LaSalle Community Action Association in Harrisonburg, and there's one in the St. Bernard Government Complex building in Chalmette. So for more information, please visit the link here. And I think we've got one more question that just came in. Let's see. So the question is, I'm an executive assistant who works for a nonprofit who also gets paid less than $58,000, who is a salary employee, which at times I work overtime. Does that law apply to me as well?
If you are covered by the Fair Labor Standards Act, meaning are they FLISA? Do they have more than 2 employees who work who affect interstate commerce? Because that's the qualifying piece of the jurisdiction. So like the secretary who talks with other states and some other, then you might be covered. I mean, you ought to check that with a lawyer. But the law, I mean, the bottom income, just came into effect. So if the minimum salary is 58,500 something, and you make less than that, it would be logical that it might apply if your organization is covered by the FLSA.
Great, thank you. That's the only other one that I see. And we're at time, so I do want to at least go over the law talks that are coming up, and have you all save the date for our future ones in case these might apply to you. So our next one will be on understanding common consumer debt issues, which will be held on March 18th at noon. And then we also just added another law talks in March that will be on common issues that affect low-income taxpayers. That one will be on March 25th, also at noon. You can find more information at our www.louisianalawyersanlibraries.org website, or you can visit our Lawyers and Libraries Facebook page to get more information there as well. And I just want to thank you, Luz, so much for such a great presentation. As you can tell from the lots of questions, this is a really important topic, and I'm glad we were able to share this and share it with everyone and get those questions answered.
It was my pleasure. And I think people need to be very interested in employment laws, because it's what we do every day unless we win the lottery, I guess.
Yeah. All right. Well, I have to shut down the Zoom. But thank you again. Have a great day, everyone.